Any mention?
Yes.
May I please, Your Lordship, I beg to mention item number 20, Your Lordship.
Number?
20.
Lakshmi Joshi.
Yes, Your Lordship, may be taken up on Monday, Your Lordship. The conducting counsel is out of stationed. Mr. K. Kharmoplang is out of station.
Lordship, we have objection regarding this. We have objection to the, because it is really urgent matter.
What are you going to do?
Monday, Your Lordship.
After 1 week? Yes. Yes. Do objections have been raised to the prayer for adjournment? It's a matter after 1 week. Because adjournment objection will be recorded. Yes. Yes.
May I please, Lordship. Lordship, we beg to make a joint mention of item number 21.
Number?
21, Your Lordship.
Joint mention meaning?
Joint mention, Your Lordship.
After 2
weeks,
weeks.
Your
Okay, yes.
Obliged, Lordship.
May I please, Lordship, I beg to mention item number 26, Your Lordship. I humbly pray this
Number?
matter. 26. I humbly pray this matter be taken after 2 weeks, Your Lordship. I've
Who
already
other side?
informed the other side, Your Lordship.
You informed?
Yes, Your Lordship.
Okay, yes.
Much obliged, Lordship.
May I please, Your Lordship, I beg to make a mention of item number 23, Your Lordship, if I pray if this matter may be taken up after 2 weeks.
Where's the other side? Any urgency here?
No, Lordship.
What's the matter about?
Your Lordship, this is with regard to the amalgamation of the two villages, Your Lordship. Amalgamation of two villages.
Two villages.
Why keep it pending? Anyway, Chancellor is not available.
Your Lordship.
It's 2 weeks, okay.
Much obliged.
Your Lordship, I'm trying to mention item number 27.
27.
Yes, Lordship.
You are the petitioner.
Yes, Lordship.
You informed the other side.
Yes, Lordship.
Yes. What's the other side? Mr. Devnath?
Yes, Lordship.
No objection.
No objection, Your Lordship.
2 weeks.
Yes, Lordship. Lordship.
Yes.
Supplementary list, item number 1.
May it please, Your Lordship.
1 second.
Lordship, this is a
Yes.
civil revision filed against impugned order dated 4th of June 2024, Lordship. Lordship, the petitioner as plaintiff had instituted a title suit,
Yes.
and the trial court was pleased to pass an interim injunction dated 15th of March 2024, Lordship. Thereafter, Your Lordship, the respondent number 4 approached the lower appellate court, and by order 2nd of May 2024, Lordship, the lower appellate court had stayed a non-existing order, Lordship.
Meaning non-existent meaning?
Non-existent order because the interim injunction is dated 15th of March 2024, whereas the order stayed by the lower appellate court is 15th of November 2024, Lordship.
Where is that?
Lordship, if I may take Your Lordship to page...
Typographical error must be, yes.
Yes, sir. Yes, my lord. It is as they claim. As they claim, Lordship.
Where's that order? Page?
Your Lordship, it's at page 81, Lordship. There, 81. Shake it to listen for you. Come there, come there, page 81. Give up typography, don't know. Come there, Nero.
81 is the case for three of appearance present, file has error, response present, so and so.
Lordship, I'm sorry, my lord. It's at page 58, Lordship.
It is order dated.
Lordship, if I may read the order, Lordship.
Yes.
The instant appeal is endorsed to my file for disposal.
This is a part of Peru's instant appeal.
Lordship.
This is application.
Furthermore, after careful consideration of the matter, the impugned order dated 15/11/2024 is hereby state, and the parties are restrained from cultivating or carrying out any other activities within the suit land. Now, my lord, the respondent number 3, on having obtained this order, filed a caveat before this honourable court, lordship.
Number 3.
Respondent number 3 is the private respondent, lordship. So they filed a caveat. Lordship, when we received that, we were not aggrieved because our interim injunction dated 15th of March was not stayed.
Where's the caveat?
Caveat is at page 60, my lord. But we are not affected by this order passed by the trial court on the 2nd of May.
No, but then the thing
Lordship,
is that,
if I may just continue, my lord. Thereafter, lordship,
now what is this prayer in the caveat?
caveat is in case we file any appeal or revision before
Look at the prayer. This case is from where? Makurwat.
lordship from Nongpo.
But see page 63.
Lordship,
Order dated so passed signing officer, council court Makurwat. What is this?
this is their petition, my lord, the respondent number 3. Lordship. So
It's from
we-
Nongpo.
It's from Nongpo, lordship. So we were not affected by this caveat,
No, one second.
lordship.
There's something wrong with caveat also.
Something's wrong with the caveat. That's why we never file any appeal or the revision, my lord.
Why Makurwat? You appeal of number 3.
Yes,
This
Lord.
is the way you draft caveat petitions.
Your Lordship, there was some mistake, Your Lordship.
This cut pasting business in the juniors has a problem. And there's you don't have time to check it also. Very irritating when you read. I've read many petitions that come here. You just stop reading petitions also just because the standard of drafting is it's really pathetic. Don't bother even to check what you file this caveat before this court and it's a sealing order of Makurwat and this matter comes from Nongpo.
Apologize, Lordship, there was some
No
mistake.
going to apology. Apologize to yourself. That's all. Yes, what happened?
So, my lord, we were not affected either by order 2nd of May 2024 passed by the lower appellate court, nor by this caveat, lordship. So, we never preferred any appeal or revision. Then again, on the same order of 2nd of May, they fixed 4th of June 2024, lordship. Accordingly, we entered appearance on that day, lordship. We filed our wakalatnama.
Yes.
Then, lordship, that is 4th of June. On the 10th of June, the counsel for the respondent number 3,
4th of June, this order is appended. This is the you
Lordship.
challenge this order.
we are challenging this order. This is the impugned order, lordship. Why, lordship? I'll go into the facts in detail.
Take it easy. Don't get too
Lordship.
excited. Yes, calm.
I'm sorry, my lord. I'm used to the other side, that's all.
Yes.
So, lordship, on the 10th of June, the counsel for the respondent number 3 physically handed us a copy of the order dated 4th of June 2024. And when we read therein, lordship, as per the impugned order, lordship, if I may take your lordship to page 84, lordship. Lordship. If I may read, lordship, the case is posted today for appearance. The applicant is present and filed haziras. The respondent is present and executed wakalatnama appointing NG Shilla and others. The learned counsel for the respondent prayed for another date to file show cause. The learned counsel for the applicant submitted that the respondents are not complying with the order dated 2/5/24. Further, the learned counsel for the applicant submitted that in the order there is a typo error as the date is typed as 15/11/24 instead of 15/3/24. Heard both sides.
Yes.
In view of the submission, the error in the date stands corrected as 15/3.
Yes.
Furthermore, the counsels for the respondent are directed to ensure that the respondents comply with order dated 2/5/24 pending hearing of the instant appeal.
Yes.
Lordship, we were taken aback because both counsels were not heard at the same time, my lord, as is the practice. So, Lordship, on the same day, we went to the lower appellate court. We obtained an uncertified copy of the missed civil appeal along with the order of 4th of June 2024, Lordship. And if I may take your Lordship to the missed civil appeal, Lordship, at page 78, the prayer portion, Lordship. Page 78, my lord, of the revision.
Yes.
At the second portion, Lordship of the prayer, and during the pendency of the case, Your Honour may be pleased to stay the impugned order 15/11/2024. Lordship, where's the typo error here? As they have prayed for, the lower appellate court has also granted their prayer to stay this non-existent order.
Who drafts this petitions like this? No, the main prayer is
The main prayer is there, Your Lordship, of 15/3/2024. This was just a typographical error, Your
It's
Lordship.
not a
It was not corrected by an application.
No,
It
Your
was
Lordship,
not
was not correct.
corrected. That's why we applied for uncertified copy,
Yes,
Lordship.
Heard you entering appearance.
Your Lordship, I will file my power, Your Lordship.
There's no, you file a power, then we'll dispose of next date.
Yes, Lordship.
This is
Will do.
absolute. I mean, this is just, you know, what exactly what's reflected. It's just the advocate's negligence
Your Lordship,
in
there was a
conducting the
mistake.
entire matter, and you litigants will suffer because of this.
Your Lordship.
Don't you bothering caveats written, mock or what? The order is written, stay order 1511. Who typed this thing? Who's the advocate?
Your Lordship, I was there, Your Lordship. Take full responsibility, Your Lordship.
Is this the way you draft petitions?
Your Lordship, there was an error, Your Lordship. I apologize, Your Lordship.
This is absolute. Heard N.G. Shillar, the counsel for the petitioners, to issue notice. Who are the respondents? Sole respondent?
No, Lordship, the Darbarshanam is also here.
Your Lordship, but for the Dorbashnam, if we just submit, Your Lordship.
Yes.
Your Lordship, when we appeared before the learned trial court, the original court, Your Lordship, Dorbashnam had appeared before the court personally and stated that they have no interest in this matter.
Doesn't matter. Since you
Because, Your
arrayed
Lordship,
them,
this,
we
They are
raised as
necessary
party there.
parties. They are
Doesn't matter.
necessary
Okay, we'll
parties,
hear
Lordship.
you only for a time
Let the
being.
trial court hear that.
So, no, this heard so-and-so issue notice. Mr. R. Kasa, whose present in court, submits that as he was the conducting counsel for the respond number 3, will accept notice and file power subsequently. Stop. For the time being, no notice to respondent 2 and 3. List the matter after 1 week for. List the matter on. After third, on 9th July for admission hearing. Meanwhile, status quo to be maintained regardless of truth land.
Lordship, I agree for the stay of the order, not status quo, because it's agricultural land, my lord.
Even then, status quo, if who's in possession?
We are in possession right
Then
now,
status
Lordship.
quo should suffice.
Lordship.
I mean,
Deeply apologize, Your Lordship.
you know, that there should be some standards in how you draft your petition and how you correct it.
Yes.
This really annoys me because the standard of drafting and the standard of really abysmal. Some petition you've read the whole thing, you can't make out what the petition is trying to say also.
Item number 2.
Much obliged, Lordship.
Apologize.
Yes.
Please, Lordship. Lordship, this is in contempt in violation of your Lordship's order dated 19th March 2024. Lordship may kindly have page 26.
20?
26, Lordship. Lordship, it appears that in spite of the matter being stated to be considered, the petitioner has been compelled to approach this court again in view of the tardy progress of the state consideration. In this view of the matter, taking into consideration the entire facts and circumstances of the case, it is directed that the state respondents positively decide the case of the petitioner within a period of 2
Yes.
months.
So
Thereafter,
when does the order pass?
This is on 19th March 2024, Lordship.
Yes, I heard Mr. So-and-so. You should notice returnable in 2 weeks. Steps taken by said AD within 3 days. Yes, on so-and-so.
Obliged, Lordship.
Item number 3.
Lordship, here the issue involved is very limited for the grant of 1 annual increment.
1 annual increment?
Yes, Your Lordship. Lordship, the fact is that I was appointed in the Assam Rifle in 1981 as Lower Division Assistant and I retired on 30/6/2021. Under basic 30th June 2021 under basic pay of rupees 60,400 in the 7th pay level. However, Lordship, before retiring, I have completed 1 year of qualifying service. So therefore, Lordship, I was entitled
Before
for...
Before you retired, you accumulated another year of qualifying
yes,
service?
increment was not granted, Lordship.
Title increment?
Yes, Lordship.
Then they didn't give
yes,
it to you?
Yes, Lord. That is the issue, Lordship.
That's an issue?
Yes, Lordship.
Yes, Dr. Mozika is not here. But Mr.
For respondent 1 to 4,
MSA Pradhan, Learned Counsel Vice Dr. M. Mozika accepts on behalf of all the respondents.
All the respondents, Lordship.
All
1
the
to 4.
respondents, no preliminaries required. Just after 4 weeks for affidavit. Yes.
All right.
Highly obliged, Lordship. Item number 4.
Yes. Yes.
Lordship, the order has been passed by the government, my lord. There are 2 orders, my lord.
In the petition?
Government directing, yes, my lord.
Which
Your
page?
Lordship will. This is 25th June 2024 by Secretary to the Government of Meghalaya, my lord. First page, my lord. With reference to the subject cited above, there are 2 pages, my lord. First and there.
It's not part of the record, my lords.
I am directed to inform you that government has decided to appeal the High Court of judgment and order dated so and so on legal ground. You are hereby informed that to withdraw the letter dated so and so.
I am at a loss. I don't know what my learned friend is doing.
We have not been supplied to the court.
Lordship,
Mr. Archival not supplied.
We are not privy to whatever has been.
Then at least you make a submission, no?
Lordship, this is the other order. We don't have
Where's
a copy.
Where's other order?
We don't have a copy.
They're not. It's not with them, Mr.
I'm sorry, as per forwarded the copies, both the copies, my lord. I will, your lordship may pass it over. I will have the copies. Matter will get disposed
What's
of.
happening to the lawyers in this court? I don't understand. Yes. Get the copies.
I apologize, Lordship.
Yes.
Daily list item number 1.
Pass over, my lords. Well, it's item 1. I'm a little handicapped, my lords. May I pray your lordships kindly grant us a little time, my lords. A week's time would be enough.
Why handicapped?
My lords, by instructing counsel, my lords, could not. You wanted to meet me. I was a little, my lords, preoccupied. Sometime, anytime next week.
Fixed on the 2nd. They are making a prayer before the trial court that since this revision is pending, the execution should not proceed. Lordship may make that observation. That the trial court will proceed with the matter.
Paul is not. He's not part of the execution now. He's gone to the root of the matter.
Correct.
Saying that if the bailiff had given the report, had ordered the decrees were executed, what?
No, I'll take your lordships to the entire order sheet.
Consequential proceedings of no.
No, I'll take your lordships to the entire set of orders and what's happened. I understand their point. I'll take your lordships to the order sheet.
My lords may have it on the 1st.
No problem. First would be fine, my lord. I would pray first, my lord.
Then my friend would not be in difficulty, my lords. First.
Yes. First. Court might have a little problem.
So lordship can have it on the 2nd.
There's a second.
Second.
Yes, Mr. Table is senior counsel on behalf of some accommodation due to personal difficulty. Stuff. Let's list the matter on 2nd.
Second.
I leave.
Item number 2.
Please, your lordship. Lordship, I'm praying for further 2 weeks' time to file my rejoinder, lordship.
How many times you prayed?
Second time, lordship.
Second time? Yes, as prayed for the 2 weeks' time allowed for rejoinder, yes.
Much obliged.
Item number 3.
Your lordship, this matter is listed for instructions, lordship.
Lordship, I'm praying for further 2 weeks' time for instruction, Lordship.
You are appearing for whom? Petitioner.
My lord, I appear for the petitioner, your lordships. This is a Section 11 petition for appointment of arbitrator.
Yes, it's only for appointment. What's happened? No instructions?
Lordship, further 2 weeks' time may be granted to
Why?
file affidavit. Lordship, we have already received instruction. We have to file the affidavit. We have
What
to.
instructions have you received? Are you opposing this application?
Lordship.
Where's Dr. Muzika? He's not well.
No, Lordship, he's on legs. Yes,
Hold it for some time. After some time, you call him.
Lordships, may I make the submission, my lords? There is a letter, your lordships, which my learned friend, my lords, is handing over, wherein they themselves admit that arbitration is there. It is their internal letter where they say that because the ENC has not appointed the arbitrator, now see the contractor has gone ahead and filed a Section 11 petition. So, my lords, it is not the case that there is no arbitration, my lords.
Yes, or this arbitration clause, correct? The courts will examine whether it's arbitration clause or not, and then we'll appoint the arbitrator then. We list it on Monday. No, not on Monday. We'll take it after some time. Let the DGSEI come. He's on legs in another court. Yes.
Item number 4.
Grateful.
Please, Lordship. As per the instruction, the money has not been received. They said make a statement on the earlier that amount has been released. So I have called a petitioner, but they have called to the office, but they are only verbally saying that will release soon. But materially, that They have not.
So the last occasion it was submitted that some amount has been released regarding the DCRG. If required, we'll file an affidavit.
What file affidavit?
If they have make any payment, let them bring any sort of letter so that maybe I also maybe.
Now, Mr. P.T. Sangma submits instructions that as per instructions received, the statement made by the counsel on behalf of the respondent on 10/6/2024 is not correct, in as much as the petitioner has not received any amounts.
Yeah.
Stop. The respondent is directed to
I'll file my affidavit along with the
within 2 weeks, along with materials showing the factum of payment to the petitioner.
Lordship.
Obliged.
Item 5.
That's on so and so.
Lordship, this matter we have taken the step that they have received also. The last occasion I have filed the
Bagmara, who's appearing Bagmara? They never appear.
They never appear.
Bagmara
This
municipality. They never appear.
In the other contempt case, this Mr. D is
3 and 4 never appear. They've received.
They have received. I have to that effect. I filed the affidavit of service also.
Who's appearing Bagmara municipal board other cases?
Some of the matters were appearing, but
You take notice. Do affidavit of service has been filed indicating service upon the respondent number 3 and 4. No appearance is made on their behalf. Stop. As is a contempt matter which deserves urgent consideration, Mr. S. Depp, who has been appearing in other matters, is directed to take instructions to inform the instructions or to inform the respondent 3 and 4. Yes, after 2 weeks, yes.
Lordship.
Just inform them, take the number, and see whether they receive notice or not. I'm not asking you to appear here today for them, just to inform them, since you're appearing other matters.
Item 6.
May I please, Your Lordship?
Where's the affidavit?
Lordship
Number
will be
6?
filing. Lordship will be filing in the course of the day.
What's the matter about?
Lordship, this matters.
You won't file? Yes. Okay, MS also submits that the affidavit will be filed in the course of the day. List after 2 weeks for gender of any.
Much obliged. Highly obliged, Lordship.
7.
Lordship, on behalf of respondent 1 and 2, I'm praying for further 2 weeks, Lordship, to file my affidavit.
3 and 4?
My Lord, I have similar prayer, my Lord.
Why? What's the hardship?
Lordship, they have sent the records. We are yet to make the affidavit out of it.
What's the matter about?
Your Lordship, there's in the mutation of the no, Your Lordship, the revenue where the between the respondent, Your Lordship, the mother and the 2 daughters, Your Lordship, where they mutated the patta, Your Lordship. Your Lordship, I would place some objection regarding they have not filed their affidavit, Your Lordship.
How many times have asked?
They have the stay.
This is the 3rd time, Your Lordship.
Third time?
They have an interim order in their favor.
Why not filing?
Lordship, the records are available. We are yet to make the affidavit out of it.
3 and 4 won't file?
We will file 2 weeks' time.
Okay, you don't 2 weeks for that time.
The interim order shall continue, Your Lordship.
Yes. Mr. S. Deb for 1 and 2 and Mr. Missile for 3 and 4. Pray that further 2 weeks' time we have to file affidavit. Stop. The same is objected to vehemently by Ms. Bijarwal and counsel for the petitioner. So, however, next in the interest of justice, 2 weeks further time is allowed to respond to file affidavit. You file it. Since you objected, next time you have to pay heavy cost.
Not sure.
Yes.
Item number 8.
Obliged.
The respondents have filed, my lord, or the sought time for filing affidavits has not yet come, my lord.
We have received instruction, Your Lordship. I'll be filing and praying for 2 weeks' time, Your Lordship.
No, last time you've seen last order.
Yes, Your Lordship, but the thing is, we have come to our knowledge that the pensioners' copy of the PPO, they have just surrendered on the month of April, Your Lordship. But in the petition, they've stated that they have surrendered way back, Your Lordship.
Okay.
And we're taking steps.
Response allowed further.
2 weeks' time, Your Lordship.
Can activities. This also.
9.
All right.
Wait, please, Your Lordship. Your Lordship, I'm praying for 2 weeks' time, Your Lordship, to file the affidavit.
Yes, Mr. P.D. Sama. Fresh matter? Not really fresh.
Matter, but
yes, aspirate for the 2 weeks' time allowed affidavit. Yes.
Obliged, Your Lordship.
10.
Your Lordship, I'm praying for 2 weeks' time, Your Lordship.
The earlier one interim order shall continue for the object. Yes?
Your Lordship, I'm praying for 2 weeks' time, Your Lordship.
Here now you add on the other, the shoes on the other foot.
Yes, Your
Lordship, I have serious objections.
Yes.
Kindly see the last order, Lordship.
Yes.
Lordship has
now
reflected.
you pay cost.
And just 2 weeks' time, Your Lordship.
No, this is
Last
second, sir. That's regarding that retail
outlet, Lordship.
Yes, Your Lordship. Your Lordship, just 2 weeks' time, Your Lordship.
No instructions.
Then we will not allow you. We'll close affidavit and we'll pass orders.
Just 2 weeks' time, Your Lordship. One last chance, Your Lordship, may be given.
Lordship has observed that in the last order, Lordship.
Yes.
Kindly see the last order.
Yeah.
Enough opportunity.
Though repeated apologies have been granted to the respondents number 2 and 3, the affidavit on their behalf is still not on board. Stop. MS Bijarwa today raised that should be given last opportunity of 2 weeks to file affidavit. Last opportunity.
Yes, Your Lordship.
In the interest of justice, the prayer is allowed. It is made clear that in case the affidavit is not filed by the next date, the matter shall be taken forward. Yes.
Much obliged, Lordship.
Interim orders. Yes.
Much obliged.
11.
Your Lordship, as for the last order, Your Lordship, I have filed small application to implead this one, but later it has come to today morning. I have filed to implead the social forest officer to RA.
Though Mr. P.D. Sama submits that a misapplication has been filed, the same not yet on record. Just after 3 days. Without 1 week.
Lordship, most blessed.
You received copies, Mr. Abraham?
Yes, I've received this morning, Your Lordship.
12.
Here we are yet to receive the record, Lordship. Waiting for some further time.
Why records are called for?
Appears, my lord, that the issue is that there are two. They are claiming an aking within an existing aking. Now there's a concurrent finding of the CEM and the EM that this issue has been settled since 1928.
What about respondent number 5 served?
We have already filed the affidavit of service, Your Lordship, upon the respondent number 5.
Office note, MS T.N. Marak, Leonard Counsel for the petitioner, submits that an affidavit of service has been filed indicating service upon the respondent number 5. Stop.
Pray for 2 weeks to produce the record, Lordship.
As such, service completes. Next by Mr. S. Deb, 124, praise for allowed. 1 week's time.
2 weeks, Lordship.
For a 2 weeks time to produce the records. This thereafter and so and so. For records and for appearance or respondent number 5.
13.
May it please Your Lordship. Lordship, I have to apologize, Lordship. We have encountered a kind of a snag, Lordship. We are unable to file the affidavit till date, Lordship. I just pray for some more time. Today is the 3rd time, my Lord.
3rd time, yes.
What's the matter about?
This is regarding suspension, Your Lordship.
Suspension?
Yes, Your Lordship. He was suspended from the year 2022, April 2022.
What instructions did you receive last time?
Lordship, the instructions we had received was that the inquiry was completed and the DP, they were awaiting court orders, Lordship. So I pray for some time, Lordship.
Who's the officer responsible? Last time there was an order also that if no such...
My Lord, that was because I was not appearing that day. That was just the second date, my Lord.
You file it within 1 week then?
My Lord, if kindly, my Lord, 2 weeks' time will be a bit difficult, Lordship.
Ms. N.G. Shilalana, CNGA prays that due to unavoidable circumstances, the affidavit be filed. She prays for the allowed 2 weeks further time to file affidavit.
Much of my Lordship.
My Lord, on the last occasion, Mr. Bhattacharya, who is appearing for the state, has sought time to bring into record, my Lord, certain facts which have been attributed to the release of this salary. That is what I could understand from the order. My Lord, I'm praying for at least 1 week time, my Lord, because of certain difficulty, we couldn't find
You're
the
appearing or he's appearing?
My Lord, Mr. Bhattacharya is the counsel for the state. I'm appearing for the day, my Lord.
Where's he?
My Lord, he is before court number 4, my Lord. His matter is, he's on a part heard matter, my Lord.
This is not salary, my Lord. These are outstanding bills.
My Lord, bills,
Yes,
I meant to
yes,
say,
final
bills.
bills, yes.
Huh.
My learned
For
friend
clearing the
said
final
salary.
bills. My Lord, clearing bills. My apology, Lord.
Prayed for a 2 weeks time allowed for affidavit. Yes.
15.
Look, this is also for affidavit.
My Lord, I require at least 1-2 days, my Lord, for type copies. Some document turns out to be quite unclear.
Documents have been supplied.
We have said so, my Lord.
My Lord, such statements should not be made, my Lord. The statement is recorded on 10th of June, my Lord. Now kindly have the order sheet of the proceedings on 20th of June. Kindly have this.
Mr. Andrew Shulai is
Lordship, we
General has made a statement that all documents have been supplied.
Lordship, they should just file the affidavit, my Lord. Instead
We'll
of
file
making
your
all
Lordship,
statements. Kindly have the second last paragraph, my Lord. Such statements are not called for, my Lord.
Where were you reading?
Somewhere, second last paragraph.
That's the ID.
The presiding officer at a preliminary hearing today. The charge officer is still on leave. No preliminary hearing can be conducted. The matter is discussed. If you review to take the case forward, bring the request for or write upon documents. Yes, you gave a copy to Mr. Shulai.
They have the copies, my Lord, all these copies. I just have one copy, I'll supply him a copy.
See the second last paragraph, Mr. Shulai. The PO is requested to look the presiding officer to the matter regarding the request, the request of the charge officer providing or related or relied upon documents before the next hearing.
Lordship, there is a instruction, Your Lordship. It says that that a list of documents based on the petition as submitted by the petitioner was communicated. The same has been done at the Lordship, it appears 722 pages of the document had been communicated to the charge officer, Your Lordship. This is the instruction, Your Lordship.
Then why does the inquiry officer say that?
He keep on praying for new documents every time the
I have
hearing
not
comes.
seen that, Your Lordship, but this is the
file the
instruction.
affidavit and
We'll
not
file the
make
affidavit, Your
statements
Lordship.
without-
We'll file the affidavit.
I will close it. You supply the documents before the next
there are
date.
other issues also.
Whatever documents necessary, you supply for next date and let the inquiry proceed. Why should we hold up inquiry
can be-
being stuck in this? Why the
Yes, the matter can be. Lordship.
Otherwise,
There are
if you have
other
any,
issues, my Lord. I'm
any
under
what other
suspension.
subsidy issues you have?
My Lord, firstly, my Lord, I'm under suspension for more than 2 years, my Lord. And also, my Lord, the subsistence allowance, my Lord, because it's not adequate. for me.
Consequential, whatever, subsidy, you're not paying.
No,
you're not
I'm
paying-
being paid, but
He
for
has been paid,
enhancement.
Your Lordship. He has been paid.
I'm before Your Lordship for enhancement.
He's not getting 50%.
I think more than he is getting.
Then, why enhancement?
My Lord, it's not sufficient, my Lord. I have several litigations, my Lord, to undergo, my Lord.
That'll be as per law. The civil litigation won't be an excuse to enhance anyway. Yes, Mr. Andy Shulai learned AAG together with so-and-so. Praise that we allowed further.
Let it be 2 weeks' time.
Time to file a detailed affidavit. Praise allowed. This thereafter and so-and-so. Brings back.
Apply, Your Lordship.
$16.
Please, Your Lordship. Your Lordship, we are yet to receive instructions from the government.
What's the matter about?
It's regarding appointment of a teacher.
Teacher.
Private respondent, my lord.
Very good. You are appearing?
Yes, Lordship.
Number 4.
Number 5, I think. Number 4 is the managing committee.
You are appearing for 4 and 5?
No, no.
Only for 5.
No, number 5, Your Lordship.
Yes, my lord.
Notice served on 4.
Yes, Your Lordship.
Yes, what do you want?
I want 3 weeks' time, Your Lordship, to
How
file.
much?
3 weeks' time.
Why 3 weeks?
Lordship.
1 second. Just relax. Yes. MST Yangi. No, wait, right. Mr. P.T. Sangma. Today's entered appearance on behalf of respondent number
5.
5. Stop. But then where do you see you filed service affidavit?
Your Lordship, we are yet to.
But the office note says that it's not received. Service reports are complete on respondent number 4.
Your Lordship, I may be allowed to check.
Yes, has P.T. Sangma had the entire appearance on respondent number 5. Stop. However, as per the office note, it is seen that the service on respondent number 4, service report on respondent number 4 is yet to be received. Stop. Yes. What do you
1
want?
to 3, Your Lordship, 3 weeks' time for affidavit.
MS Tiangi for EG
Respondents
with
1 to
so-and-so, praise allowed. 3 weeks' time for the file affidavit. Yes, what do you want to say?
Your Lordship, my submission here is because this petition is not material. Because number 1, because there is a court order from this court.
Yes.
There is order from this court on the basis of where the private respondent was appointed. Now they are not challenging the order of this court. It should be filed in appeal.
Then you put that in the
affidavit.
It's the same case where the manager didn't sign all the papers.
Yes, all the same. And moreover, that complainant is not eligible also as per the advertisement.
Very good, very good. Then you file affidavit.
Yes, Lordship.
Yes, sir. List after. Praise allowed. Yes, a similar praise made on behalf of Mr. of respondent number 5. Yes, which is allowed. List after 3 weeks. Yes.
Lordship.
17.
Please, Your Lordship. Lordship, I'm praying for further 3 weeks' time to obtain instruction. So, Mr. Sangma is.
Who's GCH Marak?
Mr. P.T. Sangma is.
Number
Can you just
15.
check? Yes. No,
Lordship, yes.
Pension?
Salary, Lordship. Praying for 3 weeks'
What
time.
instructions do you have?
No instructions yet, man. This is the second time it's coming. I'm praying for further 3 weeks' time.
As they praise for allowed further 2 weeks time to obtain instructions or to file affidavit. List thereafter and so on.
18. 18.
May I please, Your Lordship? I may be allowed 3 weeks' time to file the reply, Your Lordship. I have received the pedagogic comment, so I may be granted 3
Already
weeks' time.
received?
Yes, Your Lordship. 3
the
weeks' time
matter
may be
about?
granted. This is regarding promotion of the ICDS employee of the Social Welfare Department.
You are appearing on behalf of
The 3 to 6 state
3 to
respondent.
6.
State
And
respondent.
1 and 2?
1 and 2, I'm
You are
appearing.
appearing. Mr. Devnath is appearing. Not Mr. Dr. Mozika.
Mr. Devnath.
Okay.
Your Lordship, since we are a formal party,
It's just a formal party. So you won't file affidavit. Just have your name again?
B. Malingyang.
B. Malingyang. Right. MS B. Malingyang. Wives R. Devnath CGC for respondents 1 and 2 submits that they are just formal parties and as such no affidavit will be forthcoming from these respondents. Stop. Next. MS S. Barachaji, Leonard GA for 3 to 6 Raise for how much time?
3 weeks.
3 weeks time to file affidavit.
Much obliged.
This draft also.
Second cause supplementary list, item number 4.
Lordship,
Yes.
if I may please the orders.
You've got the required documents. The court's taken aback as to what did page 1, page 2.
I can hear my friend, but I can't see him.
Lordship, this is the first letter.
He's back. Yes.
And in
Yes.
first letter, my lord, direction has been issued to superintendent, my lord, that further orders, without further orders, he can't pass the order. And that pursuant to the order of the government, my lord, the superintendent has withdrawn the order.
Well, it's just two things. It is infructuous, your lordships are correct. Well, if I may draw your lordship's attention to that first letter.
Yes.
Well, it's, I'll very quickly just read it, Millets, because there's a little catch on it, otherwise I would not have bothered your lordships.
Yes.
With reference to the subject cited above, I am directed to inform that the government has decided to appeal the High Court judgment so-and-so on legal grounds. You are hereby informed to withdraw the so-and-so dated 7th of June until the completion of these legal proceedings. That's one part of it, Millets. And if your lordships come to the second letter, Millets, the order which has been issued on the 25th of June 2024 by the Joint Director.
NIT is cancelled.
Well, it's something which is cancelled cannot be cancelled again.
Forget about that. We'll not go.
No, why I'm saying this is, Millets, because of this. The government, Millets, cannot be given a handle where, Millets, I come before your lordships, they say very conveniently, I'm going to press the appeal and I'm not taking this order. And at the same time, Millets, in that very letter, they keep a loop open, saying that if, Millets, subsequently the appeal fails, then they will come back to the same thing. It tantamounts to that.
So we can't go on, surmises. That's all.
No, what I'm only saying is, Millets, the order under challenge before your lordships is that the tender was cancelled.
Not they've withdrawn that letter.
It's not withdrawn, Millets. That is what it should have been withdrawn.
See this one.
I'll just take your lordships to the notice.
Second letter says.
Withdraw the order.
It says cancelled.
See, due to ongoing appeal, the so-and-so.
Stands cancelled.
Yes.
Something which is cancelled cannot be cancelled by a subsequent cancellation.
Doesn't matter. They can't give any other words.
I would only pray, Millets, that your lordships record it as withdrawn.
Yes.
It has to be withdrawn.
Yes,
it cannot be cancelled.
Yes, take down today Learned Advocate General so-and-so has produced 2 communications, both dated 25th June 2024, whereby it has been stated therein that as the state respondents are since we have decided to contest or to pursue the appeal, the 7 June 2024, that is the
That is all.
That gives letter number. Huh? The first.
The first is an interdepartmental communication, Millets.
From the Secretary, the Government of Meghalaya Health Welfare Department, addressed to the Medical Superintendent of Tura Civil Hospital, whereby it has been stated that as the state respondents have decided to pursue appeal, the notice
to withdraw, Millets, you are hereby informed to withdraw the order. That is
the said medical superintendent has been instructed to withdraw order number so and so until completion legal proceedings. Copy of the letters reproduced here and below. Stop next part. The second letter, second communication, which has been issued by the Superintendent of Tura Civil Hospital, pursuant to the letter, shows that the notice tender number so and so dated to the 3rd, notice number so and so dated to 7 June stands cancelled. Stop. The said letters reproduced for the sake of convenience here and below stub. In view of these developments, nothing remains for consideration in the instant application as the impugned tenure notice has since been withdrawn. Yes, for the reasons, the matter stands closed and disposed of. Copies of the letters I've taken on board and made part of the record.
It has gone as tender notice, my lords. It's not the tender notice, it is a notice cancelling the tender.
Okay, notice cancelled. They'll reproduce it.
Obliged. Second call, item number 3, daily list.
Yes.
But this for appointment of arbitrator, my lord.
Why not appointing?
My lord, I've sent the affidavit. There are certain issues, my lord, but ultimately what it comes down to, my lord, that the department may be willing to appoint from the list of arbitrators which the Ministry of Defence.
No, they'll have to agree. The only thing is that, see, the court, if there's an arbitration clause, correct? Then nothing remains to decide.
Our case was that they accepted the final payment, my lord, without any dispute, my lord. So that amounts to waiver and the final settlement. But irrespective of that, my lord.
But that'll go for the arbitral tribunal, whatever it is. I mean, if the payments, then they'll have one facts that has to go. Whatever facts you have which are arbitrable, but firstly they will have a sitting. If there's no arbitrable dispute anymore, then it gets closed.
This affidavit has been sent for signature, my lord. Lordship permission.
How long?
1 week's time, my lord.
Okay, DSGI, Dr. Imbuska submits an affidavit has been sent for requisite signatures. If this one is allowed, 2 weeks time to file the same, yes. Yes.
Hearing, item 19.
May it please your lordships. This is the case, my lord, pertaining to appointment of Doloi, my lord, whether it should be from indigenous faith or location.
Indexed it?
Yes, my lord.
You indexed it?
Record. Yes, record. I have got the record. I have prepared the index, my lord. But some submission I will make, your lordships. Because this is, lordship, my lord, so far custom is concerned, my lord, there's some important point has been missed out. So far custom is concerned, my lord, custom has reference in only one provision of the Constitution, Article 13. Now, my lord, if you look into the definition, this is law. With any law, my lord, prevailing on the date of enforcement of the Constitution of India, my lord, that is.
What about
Constitution? 13. 13.
1 second.
My lord, if I can read it. Can I read it, my lord?
Yes.
Law inconsistent with or in derogation of fundamental rights, all laws in force in the territory of India immediately before the commencement of this Constitution, insofar as they are inconsistent with the provision of this part, shall to the extent of such inconsistency be void. The state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of the clause shall, to the extent be void. In this article, unless the context otherwise requires, law includes any ordinance, order, bylaw, rules, regulation, notification, custom or usage. So, my lord, they are talking about a custom, my lord, which prevails on the date, my lord, when the Constitution came into force, immediately before that. So, my lord, but my learned friend, my lord, if we go, my lord, that time immemorial, my lord, these will lead to huge confusion.
What does Halsbury law say about time immemorial?
Time immemorial, my lord.
There's a definition of time immemorial, you know that?
It is, but since, my lord, I will not
Time immemorial will mean what?
Not in the recent past, my lord, much beyond that.
No, there's a more concise, time immemorial.
But then here, my lord, if your lordship will appreciate one thing, my lord, our republic is just 74 years old, your lordship.
Yes.
74 years old, my lord. Now, what are the development during these 74 years, your lordship? Now, they have annexed an inquiry report. That inquiry report clearly points out, my lord, that even during the, my lord, the rule of the British, my lord, before the Constitution came into force, there was an instance where the Doloi, who was indigenous faith, my lord, subsequently he converted.
No, see,
and he continued.
Mr. Sen, whatever inquiry we are sort of embarking upon, once they are, claims on counterclaims with regard to with regard to the existence of certain custom and where that existed. Because sometimes aberration comes in when there's a stronger force. You understand? So whether the court can look into restorative kind of justice to restore something which had been practiced since time immemorial, or do we allow the aberration to continue? That's the thing.
Here is a point.
So that's the thing. So you're trying to say that okay, Article 13, fine. Customers law, Article 372 says the continuance of laws pre-constitution, that is fine. We have no quarrel with that. But only that he has to establish, that's the only thing, the petitioner has to establish that this custom was there, it was practiced, there were aberrations later on. These aberrations allowed to continue because whatever dispensation was there, we understand the dynamics. So that's the thing. So whether the court can, sitting in the jurisdiction, make an inquiry and maybe pass any orders and that's the only thing he has to go. It's not an easy exercise, but he has to attempt that. He has to satisfy the court. Now what you're trying to do is shortcut the whole process by saying custom, that one letter. No. That is fine, very good. The very fact that you bring up this point shows that there are big question marks. That's the thing. The big question mark because we thought an inquiry that had been gone into would have settled the issue. But then after you inquiry, you said that it's still open.
Yes. Well, the other thing, my lord, why just I pointed out this 13 days is the reason behind it, your lordships. Now, time immemorial, obviously, my lord, not recent past, my lord. Now, my lord, lordship will appreciate one thing, my lord. Advent of Christianity in this part of the country, my lord, Jaintia Hills, it cannot be more than 200, my lord, it will be less than 200 years. Now, before 200 years, what was it? All the way indigenous. My lord, customary institution headed by the indigenous. Now, my lord, the Christian...
we are concerned about, Mr. Sen, again, exactly. That is why whether certain section of people who have a certain belief of faith have had their rights taken away. But the fact that, a person who doesn't subscribe to that faith and who has delegated responsibility, whether it hits at the very base of custom, that okay, fine, by convenience, this has been done. And whether court can restore such a situation where that even the puja lands, the wrecks and everything that's been given, now it is given to Doloi. Now what was the function of Doloi prior? Okay, forget Christianity. Before, what was the function of Doloi at that point of time? In those areas. Now whether the beliefs of these people who are there, has anyway been impacted. That's the only thing. And whether this, like you said, the arrangement that was done by Doloi, who has converted well and good to a Lungdo, whether it's impacted their practice. If it's not impacted the practice of the Lungdo, can easily discharge, then there's no problem. They can carry on with that arrangement. That's the thing. So he has to, the petitioner, the burdens on the petitioner to show that if the Doloi is not of indigenous faith, it impacts the practice, customs, beliefs, and the performance of the whatever. That's the thing. Courts take a very level view. That's all. And if they can show, yes. If they cannot show,
my lord,
then the matter ends there. Yes.
Affidavit filed by the district council, my lord, it clearly shows, my lord, that
no, that I'll answer, my lord. I am going to answer this.
As regard to the custom, they have admitted the fact that custom has always been continuing, my lord. There is no breakage at all at any point of time, my lord. They have, in their affidavit, my lord, they have admitted that fact.
No, my lord. That is why I want to make submission, my lord. Put this thing clear.
Yes.
Now, one statement has been made in the affidavit. Where the Doloi cannot perform because of his faith, cannot perform the customary rituals, then it is Lindo. Now, my lord, in what context we have seen? That's why, my lord, I am trying to elaborate it a little bit. Now, advent of Christianity, my lord, less than 200 years. Now, before that, all indigenous. Now, the Christianity in course of time, my lord, Christian tribals, my lord, Jaintias also, they integrated in the mainstream Jaintia society. Now, my lord, here's the, my lord, evolution started. Society evolved, your lordship. Even custom has evolved. Now, what happened? Before Christianity, my lord, all indigenous faith. Now, by the Christianity, my lord, who are the substantive, in fact, the majority, my lord, they integrated into the society, my lord, slowly, my lord, not slowly, your lordship, they also became part of the traditional system. Now, as I said, your lordship, this varies from Elaka to Elaka. Now, there are certain Elakas, my lord, it is the district council. Now, he is saying that we are unable to protect custom. That is very wrong. Now, what happened in Juai, your lordships? Juai Alaga. This is our decision.
Don't draw any analogy or comparison to Juai. We look at this case in its.
I understand.
On its own
I understand your lordship because
see, you're talking about custom. Okay, custom changes. People adapt to custom. Like suppose, when the men start shaving, that time they didn't have blades or something like that. So how custom evolved? Before maybe they shaved an axe or something. Then later on it evolved. Maybe they had a better knife. Then it came to a razor. Then it came to that twin blade. Then it came to this new fangled razors you have. It's performing the same function, but it's like customary. You can't say customary to shave at an axe, but to shave at an axe. You see, custom has to adapt also to change.
Exactly.
So that is what we're seeing, that whether the change, whether the custom with the function, that as you can see of shaving, has been affected, by the change in custom.
Exactly,
that's all.
Even me, my lord, I don't know. I could not place it.
Analysis which comes to my mind. My but whether their prayers that it has been impacted because customarily and historically, and like as per the religious rights, the doloi should discharge its functions, which has been diluted because of dispensation, because of advent of Christianity, which has impacted the entire indigenous communities. Right. That's the thing. So whether this court can restore, can maybe say fine, come to a finding, if we can satisfy the court that yes, yes, positively, this has impacted, and to restore, like the doloi, if he's given these benefits for holding that office, which includes both secular and religious duties. Whether a doloi should be, whether you can, whether they can be, because one point in the Juai case was they cannot be two dolois, like one doloi for religion and doloi for secular duties. So that is one thing they have to show.
That's why I am bringing in Juai. With this entire case, my lord, inspired. If your lordship look into the pleading, entire thing is inspired by.
Hard, my lord. Argument was already concluded.
No, my lord. I'll conclude.
Only the thing is record was to be.
Record I'll produce.
It's not concluded.
Already concluded, my lord.
My lord, only few things.
It's not even heard. Even who's the other parties? States.
My lord, I have not completed. Some submissions I will make, your lordship. Now, my lord, in this back, what your lordship says.
Should you put it for division bench then?
Lordship?
Should you put it for division bench?
This, because one thing I am, my lord, apprehending, I don't know, my lord. This may not end here, your lordship. So I want to place all these things.
So you want a letter of appeal?
No. They may also, I don't know, your lordship. Because Juai, that has gone there, and entire pleading of your lordship, inspired by that Juai case of Supreme Court, your lordship. Now what they are saying, my lord, the aberration.
Anything that's useful, even suppose you draft a petition, if you see a judgment that helps you, won't you try to, incorporate the principles enunciated in the judgment?
What he is submitting, he is pointing out a statement, mainly in our affidavit. We made a statement. My lord, this is reference to, my lord, the ancient, my lord, past practice, my lord. What happened? We have said.
Mr. Sen, what this court is saying, okay, we'll hear the matter afresh. We'll consider submissions also. And, let him place his case. He understands what are the parameters of what he has to argue.
But he said conclude. He can make it.
No, you can't take now. You can't hog the entire plate. He said he'll conclude, and we won't let him argue also. So, then.
My lord, let Learned Senior place the record, my lord, and then you can.
No, I'll place the record now. Before I go, my lord, other thing we have pleaded very clearly, categorically, based on materials on record. That is from 75 your lordships till the new notification, my lord, for election, which is under challenge. That is in 2019, my lord, notification. Where all throughout the doloi had been a Christians. The last doloi, till his death, my lord, he was holding the office. Now, your lordship, I have already pointed.
These submissions were already made earlier, my lord. Again, my lord, it's
2000, my lord, 15.
Okay, you be ready. We'll hear it. Fix a date.
My lord.
Otherwise, with Mr. Sen's submission will go round and round.
Yes.
Please, you kindly give the records.
Yes.
That's one. So we can refer to it in the course of hearing.
And I have prepared an index also, your lordship. I am just putting it is inside, my lord. Index, there are 3 annexes. Now, what happened, my lord? Briefly, in 72, my lord, an order has been passed. Have an inquiry.
Let the court is familiarized with the records. If Mr. Sengon can make out a case, that's the thing. Yes, take down. The records have been produced by Mr. S. and the Council for Respondents. Number, they're really old records.
It's very old.
72, 72. Respondent number, sorry.
Number 2.
Yes, the same taken. The question also on the prayer of the party. This is a matter when we have it finished off. We come prepared. And see, you have to come prepared with with entire ammunition with regard to what is custom, what is time memorial, what is
My lord.
and not rely only on one case. With that might not be helpful to you also. Similarly, then when?
Whenever convenient to you.
We'll give a date.
Obliged.
22.
Well, I'm praying for 1 week of time. My senior counsel in another court.
Who's senior counsel?
Sri S. Pandey. S. Pandey.
He's senior counsel?
Yes, for me, yes.
Let's after 1 week, please, on the prayer of the counsel petition.
And you're obliged. 24.
Yes. Usha Nishto.
But I have received the calculation furnished by them. The issue is here, my lord, before this court, is whether for a particular period, my lord, when the dues, interest, damage has already been assessed, and ultimately at the intervention of this court, my lord, Common High Court, matter has been finally settled, amount has been paid. Way back in, payment was made sometime in 2008. Now, could they have reopened this by issuing a fresh notice in 2021, after a gap of almost 13 years? Now, my lord, if I can take your lordships to take my writ petition, my lord. I can take your lordship to page 56.
Page?
Page 56. Now, my type copy is at page 59. Lordship, my lord, it is mentioned in the first paragraph. Inquiry proceeding for determination of interest under section 7Q, damages under 14B of the EPF Act, Loreto Convent, Dhankati, Shillong. Lordship will kindly note this period, 1988 to 2001. And they have clearly spelled out, assessment is for what, my lord? Interest under 7Q and damages under 14B. Now, your lordship, if I can take my lord to Annex 6, page 62, my lord.
1 second. This is 7Q interest.
7Q. 7Q and 14B.
14B damages.
14B damages.
Period is?
Period is March 1988 to 2001, June 2001.
Yes.
Now, your lordship, they have made the assessment. Then, my lord, the demand notice is at page 62, Annex 6.
This was made 2004.
Lordship, 2004.
This has this 59, page 59.
Page 62.
When was the inquiry conducted?
Inquiry, my lord, that was also conducted, my lord, 4.
The date?
Then, my lord, come this demand notice.
This is 2004.
Lordship, 2004.
1 second.
And
for
demand?
It is 88 to 2001.
Lordship.
That's 2001, 2004, yes, okay.
Or good. And the demand notice was issued, my lord, in 22/4/2005. Demand notice. Now, Lordship will come to the page 63. They have given the assessment, my lord, and the breakups.
Yeah.
Now, total amount, period also they have mentioned, handwritten, my lord, from 388 to 6/2001.
Yeah.
Now, under two heads, 7Q, 14B. So, there is no doubt, my lord. This is for interest,
Yes.
and not for dues, not for the contribution. That was already recovered.
For delayed payment only.
For delayed, my lord, whatever interest and whatever damage they are entitled, they have done. Now, total it come to, my lord, 7,35,658. Now, being aggrieved, my lord, I filed a writ petition. There is next page, my lord. 160 of 2005.
Yes.
And that was decided, my lord, by a judgment and order dated 12/8/2008.
Okay.
Well, it's not a very long judgment, but shall I read?
Yes.
Hearts, Mr. and learned senior counsel for the petitioner, PTB Burwell, learned counsel for the petitioner, and Mr. R. Chaudhary, the learned counsel for the respondent. In the writ petitioner, the petitioner is questioning the validity of the order dated 19/10/2004 issued by the Assistant Provident Fund Commissioner Shillong, and the demand notice dated 29/4/2005 issued by the same authority for payment of damages and interest under Section 7Q 14B of the Employees Provident Fund and Miscellaneous Provision Act 1952. By the impugn notice order, a total amount of rupees 7,36,002 was sought to be realized from the petitioner for belated remittance of his contribution. There is no dispute at the bar that the penalty by way of interest and damages sought to be realized from the petitioner is to the extent of 100%. It may not be out of place to notice that the petitioner is the principal of Loreto Convent, Shillong, and that as required by the provision of Employees Provident Fund Miscellaneous Provision Act 1952, which is undoubtedly applicable to the institution in question, the petitioner is required to maintain Provident Fund account for all its employees. In the month of February 1997, petitioner received a notice dated 17/2/97 under Section 14 of the Act from the respondent number 3 requiring her to deposit her contribution dues within 7 days. According to the petitioner, in compliance with the notice, her contribution was deposited in the APF accounts in the State Bank, and in the month of April 1993, she also transferred the accumulated fund to Allahabad Bank to the APF account in the State Bank, which was duly communicated to the respondent number 3 by letter dated 28/4/98. In the month of October 2002, the respondent number 3, however, initiated a proceeding against the petitioner under Section 7A of the Act to ascertain as to whether all the dues had been paid. In the course of inquiry, the petitioner explained the circumstances under which the Provident Fund amounts were deposited in the Allahabad Bank. Apparently, classified with this explanation given by the petitioner, the respondent number 3, by the order dated 1/1/2004, directed the petitioner to deposit a sum of money, rupees 6 lakh such and such, being the balance due under the various accounts within 15 days from the date of receipt of the order. The petitioner duly deposited the aforesaid amount by challan dated such and such, also intimated the same to respondent number 3 by letter dated such and such. The respondent number 3, however, issued the notice dated 18/10/2014 under Section 7Q 14B of the Act, imposing interest and damages referred to earlier. Said learned counsel and senior counsel for the petitioner, drawing my attention to the decision of the Apex Court in such and such, submits that the damage imposed by the respondent upon the petitioner in terms of the aforesaid notice to the extent of 100% is highly excessive and contrary to the said decision of the Apex Court. In my judgment and order dated such and such, not reported, in a case which is somewhat similar to the facts of this case, I have reduced the damages imposed upon Don Bosco Technical School, Shillong, from 100% to 25%. Needless to say, my aforesaid decision was passed in terms of the decision of the Apex Court's order dated such and such. Therefore, there is no legal impediment passing an order in the nature passed by me in WPC number such and such. The quantum of damage reduced to 25%, where herein will be at the sum of rupees 7,36,000 by leaving the interest payable intact. For what has been stated in the foregoing, this writ petition is partly allows the damage imposed upon the petitioner by order of 7,35,000 such and such by the impugn notice and order dated 9/12/2004 and dated such and such shall stand reduced to the extent of 25%, that is 1,83,914. The petitioner shall also pay 1,83,904 together with interest amounting to rupees 304 to the respondent number 3 within 1 month from today. Both the impugn notice and the order shall read down accordingly. Parties are directed to be at cost. Now the payment. Lordship will go Annexure 8. Next page, my lord. Annexure 8. These are all, my lord, the evidence of. Immediately I made the payment, and next, Lordship comes to, my lord, Annexure 9. This is the receipt, my lord.
Yes.
And next, Annexure 9, my lord.
Yes.
Dated 3rd September 2008. Assistant Regional Provider, your letter dated. In compliance with the order passed by the High Court in such and such, we are hereby paying the full amount of rupees such and such with interest of rupees such and such 300, being final settlement of the amount due to you. The detail under the hearing has been deposited, hearing has been deposited, such and such. Now, when the matter ends there, everything concluded, your lordship. That we had the intervention of the courts. Now, what happened, my lord, next page 10.
For the same periods.
See, it covers the same period also, my lord. Here the law also do not permit. I'll come to the law also, my lord. Now, my lord, they issue a notice dated 5/12/21. So, 2008, after 13 years. 15/12.
15/12.
2001.
Yes.
Now, my lord, if your lordship look into this, is also, my lord, same. My
now
lord,
that earlier the alleged judgment covered periods from?
That was from 88 till June 2001.
For the first period.
That court intervention, my lord, that period. Now again, your lordship will look into it, my lord. If I can take my lords.
96 to 2014.
Yes, 1/4/1996 to 31/3/2000. But that subsequently stand corrected. Subsequently, they see in subsequent communication, this is 1097 to 4/2007.
90?
1097. 1097, that means October, my lord. October 97 to 4/2007. Now, this is also, my lord, these are also, my lord, under lordship. These are also under, if your lordship look in the top of the Annexure 10, summoned to appear hearing under section 14B of the Acts and 7Q. Now, again, damage 7Q, including the period for which it has been finally settled. Now, my lord, they have given, these are the, my lord, things. Now, my lord, I raise my objection, other thing, my lord, this was rejected. And, my lord, order was passed, your lordship. The order is at page 50, Annexure 15, page 84, my lord. If I can take, my lord, they have given the breakup at page 86. 86 in the bottom, if your lordship, before the my lord calculation they have set out the paragraph. For the reason stated above,
yes.
Page 86, such and such Regional Front Commissioner Shillong, in exercise of the power conferred under section 18B, levy damages amounting to rupees 16 lakhs such and such, only for the period such and such, the account of the breakups, my lord, now here the breakup has been given, your lordships. Here the breakup has been given. And lordship, the period they have mentioned, my lord, for the period 1097 to 4/2007. And this is the breakup, your lordship. This is under 14B again, under section 7Q.
14B and 7Q.
7Q is, my lord, interest.
Yes.
7Q interest. So this is the total amount, my lord, was imposed on me. Now my humble submission now, your lordship, if I can take my lord to the act, how it is done. You start with 7A.
Let's go to the order again of this court.
Lordship.
Where is the period written here?
Court intervention, my lord, that is for the period. Period is not mentioned in the act. In the judgment, the period is not mentioned. But that notice, my lord, the period is mentioned.
Where the notice?
Notice comes, my lord, to
Yes,
page
yes.
page 62.
Yes.
Page 63, relevant part, page 63, 388.
Yes.
To 6/2001.
388 to
6/2001. June 2001.
That means that if whatever it is, it will be from 2001 to 2007, if any amount is payable.
Lordship.
What is few act? Yes.
Now, my lord, in the act, how the dues are to be collected? There are two things, my lord. The dues. My understanding, dues means, my lord, the contribution. Contribution towards provident fund by the employer share, and also, my lord, under the scheme, my lord, for pension. Now, my lord, 7A specifically provided, my lord, how it is to be done. Who is competent to do it? If I can take my lord to 7A, determination of money due from the employers. The Central Provident Fund Commissioner, Additional Provident Fund Commissioner, any Deputy Provident Fund Commissioner, Regional Commissioner, or any Assistant Provident Fund Commissioner may, by order, in case where the dispute arises regarding applicability of this Act to establishment, decide the dispute. B, that's important. Determine the amount due from any employer under any provision of this Act, the scheme or scheme of insurance, as the case may be. My lord, here I'll just stop for a while. My lord, my humble submission, amount due. Now, these amount due, my humble submission, my lord may not accept. Dues, admittedly, one kind of dues is the contribution, employer's contribution for the provident fund. Another is for pension. Another is insurance. But my humble submission, your lordship, this will also, my lord, it says any dues, my lord. These will also include interest. That's my submission. My lord may not accept it.
No, dues can't include interest.
No, my lordship.
It's only after you determine the dues,
that will
then
be
you see if delayed payment, then interest and damage will be payable. So dues can't be, it can't be.
That, my lord, I'll come to it. That will improve my case.
Improve your case. Okay.
Improve my case. Now it will say, your lordship, and for any of the aforesaid purpose may conduct such inquiry as he may deem necessary. Now the power, my lord, like civil court power, my lord, compel the presence of the witnesses and all those things, my lord, not very relevant. 7B, I will take your lordships. In case of mistake, what they can do? 7B. Review of the order passed under section 7.1. Any person aggrieved by any order made under subsection 1 of section 7A, but from which no appeal has been preferred under this act, and who from the discovery of the new and important matter or evidence, which after exercise of the due diligence was not within his knowledge or could not be produced by him at the time when the order was made on account of some mistake or error apparent on the face of the record, and for any other sufficient reason, desires to obtain a review of such order may apply for review of that order to the officer who passed the order, provided that such officer may also in his own motion review his order if he is satisfied that it is necessary so to do in such ground. B. 2. Every application for review under subsection 1 shall be filed in such form and manner and within such time as may be specified in the scheme. Where it appears to the officer receiving the application for review that there is no sufficient ground for review, he shall reject it. So what it is saying, basically, subsequently some new documents come to the notice, or even the officer might be passing it, he finds that there is some error apparent, a review can be done. Now this is with regard to, my lord, 7A, order passed under 7A. Now it's very important, your lordships, I am relying heavily on this, my lord, 7C. Determination of escaped amount.
Yes.
Where an order determining the amount due from an employer under section 7A or 7B has been passed, and if the officer who passed the order for reason to believe that by reason of omission or failure on part of the employer to make any document or report available or to disclose fully, truly all material facts necessary for determining the correct amount due from the employer, any amount so due from such employer for the period has escaped his notice. B. Has, in consequence of information in his possession, reason to believe that any amount to be determined under section 7A or section 7B has escaped from his determination for any period, notwithstanding that there has been no omission or failure mentioned in clause A on part of the employer. He may, within a period of 5 years from the date of communication of the order passed under section 7A or 7B, reopen the case for appropriate orders redetermining the amount due from the employer in accordance with. This is very important for me. Now here, if it's an order passed under 7A or 7B, subsequently it was found, my lord, that some amount has escaped the notice because of the non-cooperation by the employer. All the documents were not placed, or it could be otherwise also, my lord. It might have escaped the notice of the assessing officer. Now what he could do, my lord, he could redetermine the amount, but that limitation period has been prescribed. 5 years.
Yes.
From the date of communication of the order made under 7A.
Yes.
After 5 years, my lord, no. So
Yes.
here, your lordship, two things are there. Limitation is there, but my lord will say that is regarding to the dues. Interest is not included. Damage is not included.
Yes.
Now here I will say, my lord, the scheme of the act is very clear. Wherever an escape amount can be redetermined by the authority. That has been provided in the statute. Here it has been provided in 7C. This is if an amount escapes, then within 5 years you can redetermine it. That means, my lord, to redetermine an escape amount, not only with regard to dues, there can be an escape amount with regard to interest. There could be an escape amount with regard to damages, my lord. This is the case, their case, it escaped. So, my lord, it is clear from here, my lord, then there should be an enabling provision in the Act that if for a particular years, my lord, some amount of interest has escaped or not properly calculated or the damage is not properly done, then it can be reopened. As it is provided in 7C, there is nothing, Your Lordship. Your Lordship, I will take, my lord, now 7Q. 7Q, my lord. 7Q, that is interest. Yes. Interest payable by the employer. The employer shall be liable to pay simple interest at the rate of 12% per annum or at such higher rate as may be specified in the scheme on any amount due from him under this Act from the date on which the amount has become so due till the date of its actual payment, provided that higher rate of interest specified in the scheme shall not exceed the lending rate of interest charged by any other thing. But there is no provision where you say like 7C, escape amount, that interest somehow miscalculated, somehow escaped the notice, then it can be redetermined within this period, nothing. So there is no enabling provision. Now, in the absence of enabling provision, my lord, they could not have reopened. Similar is the case, my lord, with 14B. You can take, my lord, 14B. Power to recover damages. Where an employer makes default in the payment of any contribution to the funds or the insurance fund or in the transfer accumulation required to be transferred by him under subsection 2 of section 17 or in the payment of any charges payable under any other provision of this Act, scheme, or under any condition specified in Condition 7, the Central Provident Fund Commissioner or other officer may authorize by the central government by the employer by way of penalty such damages not exceeding the amount of arrears as may be specified in the scheme, provided that before levying any and recovering such damages, the employer shall be given reasonable opportunity of being heard. Provided further the central board may reduce and the waiver and all, my lord. Now here, if you lordship, I have checked, my lord, entering, there is nothing like 7C for damages and interest. For dues, my lord, they have clearly provided. It escape, you can reopen it. But limitation within 5 years. Regarding interest, regarding damages, there is nothing. So in the absence of a enabling provision, an enabling provision is required. Otherwise, my lord, they would have remained silent with 7C would not have been there. Anytime they could have reopened. Now, 7C very categorically says any escaped amount can be redetermined within 5 years. But this is not so with regard to interest, damages. Now, my lord, admittedly, my lord, this notice which is under challenge and the assessment made, this pertains to the period, my lord, 1097, my lord, 2/6/2007. Now, these also covered the period, my lord, for which it was finally settled. That is up to, my lord, that is up to your lordships, up to, my lord, June 2001. June 2001. Now, you could not have reopened. Now, second part, my lord, after from July 2001 till 2007, my lord, if the, my lord, I have the instruction, if the assessment has already been made, with regard to interest and damage, and it has been collected, even for that period, my lord, they could not have reopened it in the absence of an enabling provision after 13 long years. Here, my lord, the notice was issued in 21. So my humble submission, my lord, this needs to be interfered with, my lord. This is grossly incorrect. And regarding my learned friend's submission, my lord, the tribunal. Now, your
let's go to this impugned is annexure 12. Let's examine that. What does it say? Or is it which annexure is impugned?
Annexure 12, my lord.
Not 10.
Annexure 10, yes. Yes, madam, I'm going. 21. This is a notice. Notice. To Loreto, madam, whereas Loreto Convent School is an established.
Annexure 12. Any order.
This is Annexure 12, my lord. I raise our objection. That has been rejected. That you cannot reopen it. I can read it, my lord. That is 7A, order for the period 1982 to October 1970. Challans and letters showing the deposit remaining assessed amount, that is rupees such and such, dated 17/2/2003. Damage notice for the period 5/1/1989, along with the final order and the court order. These are the main contention of the establishment. The damage dues has already been paid, and there was an overlapping in the calculation of the current damage dues and previous damage dues. And the Honorable High Court already pronounced the judgment in his favor by waiving off the damage to 25%. On going through the submission, B is the previous damage dues calculation, Honorable High Court judgment and challan submitted, and the letter forwarding to the office informing regarding the deposit of the remaining 7A dues assessed and 7A order, the current damage dues calculation here are the finding of the undersigned. Very difficult to answer. The said from the wage month 1097, there is no one-to-one correspondence between the period of damage dues, that is one initiated in at 18/10/24 for the period 3/1998 to
Doesn't make
6.
any sense. Who writes orders like this?
My lord, this is very difficult to understand this language.
Who's this fellow?
He is one Mr. Neetham.
He's the assessing officer or the Provident Fund Commissioner?
Regional Provident Fund Commissioner.
He writes like this.
But it's very difficult to understand this. In regard to the query from the establishment that why the same wage period 1097 occurred twice in both the damage notice, as can be seen from the challan submitted, letter of payment confirmation for remaining 7A dues to be paid, dated such as such, it can be clearly seen that it is an area of dues payment whose delay has not been taken into account in the previous damage notices. So they are saying escape.
Whose fault is that?
This is an escape, he is saying.
Not escape. We have not
yes,
want.
Just see this line. It's an area of dues payment whose delay has not been taken into account in the previous damage notice. So you didn't notice it in the previous damage notice. As such, penalty is imposed now. So now penalty be imposed on whom? You failed to assess it at a point of time. Now you're saddling them with penalty for the delayed payment.
Late payment, Lordship.
See this paragraph again.
Yes.
In regards to the query of establishment that why the same wage period of 1097 occurred twice in both a damage notice, as can be seen the challan submitted, letter of payment confirmation for the remaining 7A dues to be paid, dated 17/12/2004, submitted by the school's office. It can be clearly seen there's an arrear of dues payment whose delay has not been taken into account in previous damage notice. Was this demand ever made in the previous damage notice with regard to this? Then why are you charging them penalty?
The demand, the present notice. In the present notice, it may be of the present notice may covered for example, I am giving 2001 may have covered, but the months may, or the previous it is like it has not covered the dues paid on each and every month. Sometimes it is it is through the systems it comes out.
Just read this one. Just try to explain it to the court. Court was at a loss. You see his finding.
Yes.
He says that it can be clearly seen that is an arrear PF dues payment whose delay has not been taken into account in the previous damage notice. So you already levied damages upon them, and as such penalty has been imposed. So now in the previous notice it's given for unpaid dues. Now at that point of time also damages had been levied for which they had paid whatever fraction as per the order of the court. As such penalty be imposed. Now do you mean to say that that is this non-factoring in of this previous arrears, whatever arrears of dues payment? I can't make out head or tail.
Lordship, here my learned senior has submitted under 7A and...
No, just decipher this line for
I'm
me.
I'm coming. One by one, I'm coming everything, each point. Here what happened, suppose date is 17/2/2004. The 17/2/2004. So within 15 we know that they have to pay. Now this 17/2/2004 is paid for which month? That also is not in 17/2/2004 there might be multiple payments. If I can explain more, suppose for five.
Code into a more darker space.
No. I'm explaining. Suppose Lordship.
Why does he say?
Suppose Lordship, I am giving an example.
So we'll try to simplify it.
Suppose Lordship,
Just simplify it. Just simplify it. Okay. Letter of payment of confirmation for the remaining 7/8 dues to be paid, dated 17/2/2004, submitted by the school's office. It can be clearly seen that is an arrear PF dues payment whose delay has not been taken to account in the previous damage notice. Where the previous damage notice?
17/2/2004.
They are referring, because we are referring to that ultimate settlement made by the court. That's what we placed before him. That this period already done, where you have reopened.
That is why the school is trying to find out whether this order, this daily order, he says that, since we do not, in the earlier damage notice, we do not give these damages, we do not levy these damages. So now for that, for the fault of us, that we did not give the notice demand, so please give us your inflicted this penalty. That's it comes out that way.
Please come to page number 70. Please come to page number 72. 17/2/2004. What he is referring to, I'm trying to explain that. Please come to page number 72. Suddenly, actually, Lordship also suddenly went to that order without checking.
Suddenly, okay. This will
That
not
is
be
why.
sudden, yes. 72.
72. Page number 72.
Okay.
In the first column, it is written 1097.
Yes.
And 15/11/97. Now here it is coming to 7/2/2004.
Okay.
So 7/2/2004, the order was the judgment was decided in 2008.
Yes.
They paid the amount prior to the judgment. The judgment, the case was not filed during 2004. They paid the amount, but 17/2/2004. So, Lordship, the previous that annexure A, the same type of calculation would have been there in previous when the judgment was passed. We have to match both the.
See one thing, okay, we understood. Now see already delay days under 7Q 14B already there. You see,
Yes.
7Q, okay, 14B. So now the amount, you already said, 456 and 608, correct?
Yes.
Yes. So this amount has been reduced also, correct? By the judgment.
By the judgment had not been covered in the annexure A of that notice. Because
No,
that
no,
notice,
just see.
we
Now
cannot
7-2
come
now,
randomly,
just
Lordship.
listen.
We cannot come randomly, Lordship.
Exactly. Now that's why we can't be random also. See, now you say that the penalty has been inflicted because in the earlier notice for damages, that amount had escaped you. That's all. It amounts to that. And so in this page 72, you're showing that, okay, fine, the Chalan wage month was for 1097 and the duty presentation should have been on 1511. It was not done. It was paid eventually on 7/2/2004.
Yes.
And such the delays under 7Q, were factored in, and 14B, correct?
Lodge.
As 2285, 2285, right? So
Lodge.
component of 7Q, 14B, then account 1, account 2, account 3, so and so. So with the component, it comes to 456 and 608. Now over and above this amount, what I understand is that you're saying when this was factored, when this was calculated and computed, some amounts escaped, and that is why you're inflicting penalty on those amounts.
Lordship, Lordship, it may not be escaped also.
Well,
Lordship, Lordship, I am explaining.
But we don't inflict.
Lordship, if I explain more clearly, Lordship. Suppose, Lordship, I am myself and my friend is working in one company. For month of November, my challan is submitted, but my friend's challan is not submitted. So what happens? Subsequently, the number submitting of challan date, this 17/2/2004 is reflected. Now again, after a few months,
For the same period.
for the same period, it is coming for my friend.
Where is that?
I'm just giving an example. So might be the case is that when it can be a multiple dates also. It can be in single date also. So Lordship, that is why when order is passed under 7Q and 14B, there is a provision for appeal. When there is a conflict between that which to be accepted and what to be accepted. Might be the school is having lot of data which school needs to produce. During the hearing, they could not produce. Might be the order is passed, and the provision, that is the provision for appeal, is lying that yes, the evidences is there where the oral evidences also may be counted. That yes, the accountant has submitted this data. Now for one day, multiple dates may come up. For my friend, for myself, because the challans are submitted.
Understood. That your understanding is perfectly
and,
clear.
And
what I don't understand the language here. That is what. Understand this that. I understand. You mean to say that for this, in the same date, there were other payments that were made?
Yes.
Which are not taken into consideration?
Yes.
Then whose fault is that? That's what the school's asking.
It is the school's fault because they have not paid altogether. Suppose 19 employees are working, for 15 you are paying, and for 5 you are paying on subsequent month.
It can be clearly seen as an area of PF dues payment whose delays have been taken into account in the previous damage notice. See, the earlier damage notice that you've shown, that means that the delay has already been shown, this is the amount of days, and this is the penalty, and this is the interest that you have to pay.
Yes.
Correct. Now, what is court asking, after it comes to that finding, notwithstanding anything that happened internally or externally between the commissioner and the school.
Yes.
Now, whether you can reopen the whole thing at a later stage and say that because, at that point of time, when we gave the damage notice to you, these amounts had escaped. Maybe on the same day some other payments were made, which should have been factored in, and damages and interest calculated. Now for that, whether you can impose penalty now after how many years? That's the only thing.
It is with due rectification. It is not escape amount. I am saying it is not escape amount. It is saying that
penalties imposed.
Penalties imposed and whose delay has not taken into account. It is like. What I explained. So for few employee you are submitting, and subsequently you are submitting for other employees. So when the notice is calculated, when the demand notice is calculated, then there is also a confusion that this has not been. After thorough examination, we found out that yes, for these 5 employees you have not submitted during your previous notice. So there may be a multiple submission of challan. Multiple submission of challan may be there. We cannot say that for one.
What happened after this order?
Lordship.
After this order was passed, what happened?
After this order, they have deposited. Then on thorough examination, we have found that the dates which we have mentioned in 72 and page 73, they have. Correct. They have caused delay in payment in
now, how do you explain about the 5 years and the 5 years cap
5
period?
years is for 7. The assessment is not under 7Q and 14. This assessment is under 7Q and 14B, not under 7A and 7B. The determination of scheme amount is under 7A and 14B, 7B, not under 7Q. It is, we have not undergone under 7A and 7B. There is, when 7B arises, under review, if appeal is not filed, in 7B it is saying that appeal has to be filed.
Yes.
When appeal is not filed, then review can be filed. We have to file, they have to file a review application for us that we have not filed appeal, kindly review the order. They have not gone on 7B. They have not filed, there is nothing under 7B. No order is passed.
How do you reconcile that the periods between covered by that order of this court and for the extra damages that you have imposed for that period only, which is also covered by earlier order of the court, because this is from this is for the period 1097 to 427, correct?
Yes.
And the order of the court was 2008.
2008.
So what are those amounts that have been reduced to 5%? Will not be covered by this.
That will be covered for that assessment years, but with respect to that annexure A.
Now what about now? Okay.
Annexure A is not enclosed of that.
Now for that, when the matters before the court, it covered which years? Which year was covered? That reduction of 25% with the paid 1,83,000, which for which years?
The judgment.
2001. That was from Mr. Sen. The period was from 388 2001. So 97 is covered.
97 is covered, but
yes.
That is what I'm saying. 97 is covered, but subsequently when...
Subsequently, are you referring only to the period from 2001, 2007 then?
Lordship, I am...
No, that is what this court wants to know. Because, see, you cannot revisit a matter twice before the court with regard to the same periods which has been adjudicated, okay? Now, if the period adjudication that was up before this court was for 388 2001, and the order part 2008 was, okay, fine, reduce the penalty and the interest together cumulatively to 25%. That was paid by them. Now, again, you come with the subsequent proceedings where it covers the period also that, okay, up from, 97 to 2001. So what are we dealing with? Are we dealing with the period only from 1 to 7, or you're still rewinding back to the earlier period also?
No, but the judgment, what is passed, we are accepting the judgment. We are not saying.
Now, for which period are we concerned with now?
That is what the Lordship I am saying, that annexure 1, when annexure A, when it was assessed, the court also has to, it is, I can means what to how to explain. Lordship, when a month
how to understand also, for how to explain.
Lordship, suppose what I explain is that
I'll give you a clue. When we are young lawyers, so at least during our time, we were taught one thing. They said that when you present your case before the court, you assume that the judge knows nothing.
Lordship.
He knows nothing about the facts of the case. He knows nothing about the law.
Lordship.
Okay. So what a young lawyer has to do is master the facts and apply the law. Correct?
Lordship.
And so it's like telling a story to the judge, making him understand that this is the fact of the case. Okay? Just assume the judge is blank, zero out here. Doesn't know anything about the case, doesn't know anything about law. Then you explain that this is the case, this happened chronologically, this happened A, B, C, D, like that.
Gotcha.
Okay. Then the judge maybe digests the facts. Okay, this is what happened. And then you apply the law, said because of this is applicable, this is what happened, this is the infraction, so on and so forth. And here is the illegality, or here is how I support my case. That is but pretend that like I'm at sea now, I don't understand, because you're submitting, you're trying to satisfy the court. I am trying to understand also, but I can't get the periods for which the assessment is done. I can't get the periods for how the damage has been calculated. I can't get why you've revisited the entire thing and reopened the whole thing. May granted it's not a 7A, but what are the circumstances which warranted such, in a clear manner. Like this is what happened. They paid on so and so, maybe these amount. This is what happened. That is why the proceedings were reopened. That is why we saddled them with the notice. And because of that, the law that applies on the 7Q and 14B, you know, they're not dues on the 7A, there's a penalty and which, you know, they can be imposed any time to recoup the amounts which maybe the Provident Fund could have, you know, used for, you know, is a social beneficial legislation. We understand that people have to pay because it goes towards, you know, many things. So that's the thing. So please explain to me in a very coherent manner that
I am giving my 100% to explain, Lordship.
100%.
Yes, Lordship. Lordship.
You need to give 200%.
Lordship, now the thing is that,
yes.
suppose what I explained, suppose
Yes.
for 20 employees are working, for 5 of them they have not paid, Lordship. Okay. So subsequently, the assessment has come for 5 of them. Now, Lordship, during that tenure, what had happened is that Annexure A, might be the court has not gone into deep in the annexure, which are the assessment months when we have calculated. Because what I have already stated, suppose for 97, they already paid. 97 they have paid, but not for entire employee, not for all the employees. Might be for one employee they paid, and that is why 97 has come into account. What about the other employees when they have paid subsequently, they realized that yes, for other 19 employees we have not paid, and that is why the amount has come to 6 lakhs. Because they have not paid for all the employees, because there are other employees are also there. So when they have subsequently placed, because 2004, 97 paid in 2004 is not the tenure, because the case was judged in 2008. The case was judged in 2008. So 97 paid in 2004 is very much covered.
You have the writ petition of this writ petition. You have it. You can produce it.
Well, I will try.
We'll see what period.
Now, Your Lordship,
because the judgment does not reflect that.
Judgment does not reflect. That is why I am saying that.
That's why the confusion also is there.
No, my Lord, I think the impugn order we have not gone through. The finding is very categorical of the assessing officer. That is, if Your Lordship come to page 85, my Lord, his findings are there. Now, what his findings are there, the submission made by the employer has been examined and the reference to the material and records rule proposition laws laid down in this regard. This is his finding. 1. The wage period month 1097, it can be seen from the challan submitted that the belated payment is not saying that some has been paid, some were not paid. That is not the case of the assessing officer. PF dues pertain to arrears payment of PF dues by the employer whose delay in payment was not taken into account in previous damage notice. Hence, there is no overlapping. Same thing, my Lord, what I am submitting. He is saying it escaped. And if it has escaped, what my learned friend is making submission, some has been paid, some has not been paid. This is not the case of the assessing officer. Lordship, we will kindly go through it. What I am saying, Your Lordship, escape amount, with regard to dues, there is a provision 7C. Now, with regard to interest, damages, there is no such enabling provision. If there is no such enabling provision, you cannot reopen after the assessment.
Lordship, if that may be mutually understand, Lordship. That may be mutually understand. Let's produce the annexure A of the previous demand notice.
Where's that?
It may be with them, because we have already given them.
Because see, the only thing that if it overlaps with the early order which has been, we've got relief.
Lordship, if it is overlapping in the earlier order from the previous notice, when it is each month will be there for annexure A, each month will be covered.
Exactly.
So whether overlapping or not, we can easily find out from that.
You have that records with you.
No, Lordship, 63,
Might be there
that
in
period,
the office.
that writ petition,
because we have shifted from Barik, from Limekra to Barik, so I'll need some time to search out from the
Lordship,
office.
what I am saying, my Lord, regarding the period.
Only that period.
No, period. Just if I can just clarify, my Lord, what period Your Lordship?
You're running around circles.
No, my Lord, which period Your Lordship is referring to? Which period?
The court wants to know,
Lordship,
this judgment whereby the penalty and damages were reduced to 25%. It's for what period?
This is there, my Lord. I have
notice given annexure A. That A notice. Where's that notice?
63, Your Lordship. Notice of demand, it is reflected.
That is for the earlier case.
Yeah, this is the case.
For earlier case.
Yeah, earlier case, my lord.
Where is that? Page 63.
Page 63.
This is for the earlier case.
Yes, from 388 to 6/2001. Page 63.
Okay.
This 388 to 6/2001. This is my entire case. Is this, my lord? Without this, how can?
Okay, Lordship.
So now, okay, fine. Another aspect. So, what about the period 2001, 2007 then?
My lord, that period, my lord, this cannot be segregated. Now I have looked into it. If you look into the assessment, this cannot be segregated. Other thing, my lord, what I am insisting, your lordship, even if for that period it is already assessed, are they empowered under the Act? Again, I am saying, my lord, 7C for escape amount, dues, my lord, there is a clear categorical provision to reopen within 5 years. Regarding damage, interest, there is no such provision to reopen. And that you cannot do it. From 7, if your lordship count, or 8, after 13 years, you cannot reopen. And regarding the period, it is very categorical.
When you bring the petition, you get the record. What the WC is that?
160 of 2005, my lord.
160 2005. Yes.
160.
We'll have next date. I'll go through it also beforehand.
Lordship, here, page number 52, Lordship.
We'll have next date. You come fully prepared.
Lordship, page number 52.
Well, I'll try to find. This is a very interesting.
Have any authority on this? On reopening the escape amounts when there's no enabling
when there is no enabling provisions. Okay.
Or is it it's a consequential if you have to pay interest and damages.
Lordship,
escape amounts.
Lordship, page number 52, Lordship.
Very clear.
Lordship, page number 52. I have page number 52, Lordship. Comparing with page number 72.
Oh, we'll get it from the records.
I think he has one.
We'll have it next date.
Lordship. 25.
Obligement.
It was court if we can't find a definitive, ground where we can adjudicate, it becomes very difficult.
No, but I'll see, without enabling provision, if I find out something else.
If we get the authority, we'll dispose of next day. It's been pending long enough.
Oblige.
Yes.
25.
Yes.
Only TSG is on legs.
Ready?
No, Your Lordship.
No.
Your Lordship, actually, Mr. Thapa is actually looking after this
Where's
matter.
Thapa? I thought I saw him.
He's also on legs for the same matter on court.
Maybe after 1 week, yes. Due to unavailability of the arguing counsel. They are together against each other in the other case.
Your Lordship.
28.
Highly obliged.
We'll take it after some time. He's here.
Yes, Lordship. After some time.
When he comes, yes.
29.
May I please, Your Lordship? My Lord, with your Lordship permission, we want to withdraw this writ petition with the liberty to move the file before the appropriate civil court, my Lord.
This is for ownership of the school?
Yes, my Lord, that's correct.
Yes, Mr. L. Shongwan, learned counsel for the petitioner, prays that we allowed to withdraw the incident application with liberty to approach, to avail of other appropriate remedy. So the prayer is allowed. Matter stands close on withdrawal with liberty as prayed.
Highly obliged.
Mashallah.
Bajuk bien. Kayak ini apa? Only your matters left.
A lot of adjournment has been taken, my lord.
No, but he's not available. He has not been well also. No, it's not that we have to pass the orders only.
Yes, we have to pass on. You have already passed on 24/4/2024, and I have agreed. And your lordship may kindly pass the formal order with a time frame, failing which some will carry the interest. That is my humble submission, your lordships. You have already passed the order on 24/4/2024, and I have agreed.
What about interest?
Yes, interest, if they do not pay within certain time, then that will carry interest.
There is no interest now, only 60 lakhs, satisfied.
65, yes, because it is at the instance of suggestion of the court, I have agreed.
Yeah.
Lordship,
So,
you may kindly think up this matter tomorrow, Lordship.
no, my lord, it is a, no, you.
No, we will pass orders.
Yes, my lord.
They can't have to pass in their presence, otherwise he'll
Yes,
be held accountable. We'll take it up tomorrow, we'll pass orders.
Yes,
Positively.
Much obliged.